legal information
everybody out.
as legal advice. We never give or provide legal advice. We are not bar license attorneys. If you want a bar license attorney and you want legal advice, we suggest that you go see one. All the information that's discussed today is strictly for information and entertainment purposes only. Once again, we never give legal advice, but we do share all of the legal information that we can possibly share. Remember, we are not attorneys, we're not a law firm, and we're not a substitute for attorney. Anything discussed on this phone call today will never be substituted for bar license attorney's advice if you want that. So with that being said, I feel good enough. Larry, you okay with that short disclaimer?
Okay, Larry evidently did not come in under the...
he said yes.
Oh, did he?
Yeah.
Okay.
You go ahead and do what you're going to do, Jeff, and then...
okay. Well, by way of introduction, most of you have already heard from Jesse. Jesse has been in the foreclosure fighting field now for about 7 years, and in the credit card debt collection for about 5. Larry's been doing the credit card debt collection counteractions for the last 5 years, I believe, unless it's been a little bit longer than that, Larry. You can always correct me on that. And John he's kind of a landmark. He's been around forever. Now, John's been, I know it goes back at least 10 years that I know of. But he's been around in the debt collection and the fighting debt collections for at least 10 years that I'm aware of. So between the three of you, did one of you decide which one was going to lead off and start?
Well, it doesn't matter to me. I'm trying to help Larry. He says he can't find the darn stuff running around, so hold on.
Well,
let me give it to him.
John, why don't you start off? You there, John?
Yeah, can you hear me okay?
Yeah, I need for you to speak up a little bit, please.
Okay.
Or
you
turn your volume up.
Okay. Well, thanks for the call. I appreciate the opportunity to talk to everyone. I think as much as I've been doing this for a long time, I really think each of us have different levels of expertise. I think that Larry has his expertise, and I really learned a lot from him. And the same with Jesse. He's really got an advanced knowledge and skill on the mortgage foreclosure and really judicial procedure. And I've learned quite a bit from those guys in the last couple of years. So I don't know what else to say. I mean, what do you guys want to lead off with? You want to talk about a particular subject?
Well, kind of, John, just touch on what you do because what together on the website. I think let's make an introduction of you and why we're here.
Okay.
We started a website, and just I'll take over for a few minutes, John, and just kind of give them an overall view of and an understanding of what we do. John's been around, like I said, he's an icon. He's been around forever, but John's specialty is in getting you bulletproofed, in essence, making you disappear off the grid. I'm sorry, I'm going to take this thing off speaker, so make sure you guys can hear me clearly. Anyway, John's expertise is basically getting yourself off the grid, protecting your assets, et cetera, et cetera, et cetera. And he does a hell of a job, whether the system is, like I said, it's been hacked. I think I talked about this a month ago on our last call, Jeff. They actually hacked. Some attorneys got John's material, started selling it, and he wound up getting a $2.3 million judgment against him, against attorneys for using his material. So that tells you how good his material is in making you judgment-proof and bulletproof, hiding your assets, and not hiding it from IRS, but from creditors. Okay, so it's really got nothing to do with the IRS. It's just protecting what you have, with your family's assets. Personally, myself, I've been beating up on the foreclosures of David Stearns of the world that's finally out of business for quite some time. And same thing, helping the families keep their homes. We had a pretty big real estate business here in Central Florida and other locations. And we used the foreclosure, because that's how I got started way back 10 years ago, was stopping foreclosures rather than reinstating these loans. And Larry, same thing. Larry's been doing counteractive FDCPA, FCRA actions against these guys, the debt collectors and the credit card companies for years and years, and winning very successfully. So what come to pass was, after months and months of in early 2008, it was, of seeing all these guys out there offering these administrative remedies, all these God, I hate to call them, but it's a bunch of nonsense. remedies that are out there. Families getting hurt. People calling me. I paid so-and-so $5,000. I've paid so-and-so $3,000. I got thrown out of my head. One client said, I paid this guy $3,000 last week. I'm literally on the street today. It was 7 days later. It was incredible. Wouldn't return her phone call, wouldn't do anything. I got really sick and tired of that, and what I was doing is handling a select few. I have about 500 active cases that John, thank God, helps me every now and then. We work together every single day in the office with some of the paperwork. And I thought, we got to get this spread out far and wide, give something back to the people that they can use. It's simple, that's easy to understand, and it's affordable. And the problem that we've seen to date is it continues to run rampant out there, these people getting ripped off. And it mind boggles me where people will pay $5,000 to still have to handle their own entire work. Matter of fact, I had a subscriber email today, and I'm not going to name the other site, obviously, but it was like $900 to join and $20 a month. And it's another one of those administrative processes, get your houses free and clear, all this nonsense. And I actually have a very good friend of mine, longtime associate of mine, that actually used that system, paid $3,500 and lost 2 houses to the system. and he's willing to tell you it don't work, because people seem to forget that if you're using these oddball processes out there, that people are getting big money and giving these poor homeowners high hopes. If you have a bad judge who doesn't give a rat's behind about anything, he's going to storm right through you and all that paperwork. As a matter of fact, I have a very good friend of mine for using that administrative process who is serving right now, as we speak, 10 years in jail. He just got sentenced a few months back, and they went and picked him up, and off he went. And I can verify this because if I already give this name out, I guarantee somebody on this phone is going to know him, because he was out there pushing this administrative remedy with another gal. And from my understanding is she's in jail too, but he's in jail. So this kills me, Jeff, and it kills John. John's a very giving guy. As a matter of fact, John, I don't want to toot your whistle, but, there was a big 60 Minutes deal with homeless children due to these foreclosures, and I forget, what was the guy's name, John?
David Corfey.
Yeah, David. And this guy shows up in my office Monday. I'm like, John, what the heck? Where'd he come from? He was on our news. He was on 60 Minutes just Saturday. And now all of a sudden he's at my office. Well, John and his wife ran out, bought him a bunch of gift certificates, gave him some food, gave him some money, his kids are barely enough to wash or brush their teeth. This is ridiculous. The news totally underplayed this. So it goes, it goes to show you the kind of heart that we come from and the honesty. We don't want anything from the guy. We don't want, it's here, man, you need to help, and so in designing this whole thing, it took us a little over a year. And I said, we got to be able, number one, to give them something that works. Number two, they can afford. Number three, that'll actually pay them back. And I know it sounds like I'm asking for the world, but our system actually works. So, knowing John, working with John for 2 straight years, every single day, knowing his family. I met Larry through another friend of ours, a mutual friend, who's also very much active in the FDCPA, FCRA, et cetera, suits and teaches people how to do that. And I says, you know what, this is great. We're all local. We all can meet. We all can discuss cases. We can all do our research together. And I'm putting this together. This is my grand idea. I really need your guys' help and guidance on this so it'll come to pass. And sure, thank God, it's come to pass. So, the way we did it is a small monthly membership, but it's not a big money up front. There's not something that we guarantee you this or guarantee. What we guarantee you is you're going to keep your home, you're going to stay in your home, you're going to stop debt collectors, and you're going to stop credit card companies. But the bonus is you get paid. That's the bonus, and people have a hard time understanding that. But our members, our active members, understand this, but you have to be proactive. So long story short, I'm going to cut it right there. I want you to, now that you have the understanding, is it helps you stop your foreclosure. It helps you stop credit cards. It helps you stop debt collectors, gets you paid. And now that you've gotten paid, you've stopped all that. Now you know how John's system falls into play, which in essence bulletproofs you from all judgment. So you have 2 choices. You can use John's system, implement it, walk away from everything and say, the hell with you guys. I don't care. Sue me. You can't get a penny. Doesn't matter. Or you can do what Larry and I and John do, which is have a little fun and make them pay. So when I do get the money, it goes and disappears so some other guy can't come and get it. So either way, it's a full system. And I'm telling you that if you were to try to replicate this, and Jeff, you know this because you've been involved in all this in the past, and a lot of people on this call know you're going to wind up paying $5,000, $6,000, $8,000, $10,000 for this. And we said we don't need it. We want the volume because the only way we're going to change this country and help these families in a mass is to make sure that we can make it affordable for everybody. But more than that we teach everybody how to get paid from these guys and how to put the hurt into them, because that's the only place that's going to put the hurt into them is in their pocketbooks, nowhere else. So with that being said, Larry, are you finally there?
I am here. One thing I'm not sure if you covered, Jesse, but you've been dealing with a lot of people's foreclosure issues. How many houses have your clients lost?
0.
Okay, that's a pretty
0.
good number.
And actually, one of my clients of a few years, Greg, is on this phone call because I heard him introduce himself. And he can vouch, and I'm sure Randy and several others are on this call that are some of my local and a few states away. Let's put it that way. That can vouch, and they're not setups. They're not people that I asked to get on here and do anything. They don't have to talk a second. You don't have to believe a word. But we have yet to lose a home. And as a matter of fact, in Greg's particular case, we're in an appeal now, and they've had to hire other attorneys because I did a 1.5-page brief is all. Larry knows my little famous brief, and all of a sudden they're running scared, and the court's giving them some orders, and they don't know how the hell to respond to it. So all they do is keep filing extension after extension after extension. And in the meanwhile, we're going to sue the hell out of the other attorneys. So, our system works, and that's all we can say. But, Larry, I want you to talk a little bit about what you do and what you've done and your success in the past.
Sure, and I just want to kind of build on what you were just saying, which is that what you've done is kind of permanently delayed foreclosure. And you can probably keep on doing that year after year after year, but we're working on developing systems that are even better than that. We're actually going to get foreclosure cases dismissed and, the judgment and if you have one, or the mortgage just completely out of the picture. And again, we're not going to guarantee anything, at least not yet, but we're working on systems, and we think that these are going to be very successful. So as we develop these programs, anything that we know, we're going to put on the website because we want to share it with everybody. Basically, from my standpoint, as Jesse said, I filed a number of mostly cases in federal court and taken tens and tens and tens of thousands of dollars from credit card companies, from collection agencies, from credit bureaus, and these are particularly for violations of the Fair Debt Collection Practices Act, the Fair Credit Reporting Act, and something that we're getting into more and more right now is what's called the Telephone Consumer Protection Act, which is when you get certain kinds of phone calls, whether it be pre-recorded messages or phone calls to your cell phone, especially, or your home phone, especially if you're on the federal do not call list. But that's one of the things that we're really working on to try to develop systems that are, again, the key is to not only get these people out of your life, but to get them to pay you money before they do that. And like I said, I've collected tens of thousands of dollars so far in settlements and judgments, and I'm just getting warmed up. I've got a lot more defendants that I'm in the process of suing. I'll probably be filing myself some additional lawsuits as well. So this is the kind of thing that we really want our members to take advantage of. And as Jesse said, we're going to give you the information, we're going to give you the resources, and, we're doing the webinars, we're doing the forum, but you got to be proactive. And one of the things we really want to emphasize is this can be a lot of fun if you know what you're doing. And you start, changing your life and getting money in your pocket, and that's the goal, and that's what we want all our members to take advantage of.
Jeff, you want to open this up for questions?
Well, how about John? Let's have John step out and speak on his specialty.
Well, I can speak on mine. I can't touch what Larry and Jesse's done. That's awesome. But what I've done over the years is I just avoid controversy. So for years I thought I could be a smart guy and go in there and try to argue collection cases, and it doesn't work that well. So what I decided to do was just create the same debt scenario that the banks were creating against people that I was helping. So, for example, if Citibank sues you, you get the judgment lien, they can garnish your wages. And so then Discover can sue you, and then when Citibank is finished garnishing wages, Discover can then garnish wages, so they have to wait in line. So when I realized that, I decided I would just create a lawsuit, judgment lien, and put that in front of every creditor in the world and keep it there forever because it's a friendly debt. And so that's the system I set up. It takes about 3 months to put in place. And then the other people that don't have wages, if they have cash in the bank, we can avoid the bank levy even from the IRS by simply changing the relationship that the people have as a signer on the account from, like you normally have, a personal signer on the account. We change that to a corporate account so that the signer does not have exclusive rights. So just a couple of changes to your relationship to property and money is enough to preclude the entire world, with very few exceptions, that is, from taking any of your property. So I just put that system in place, and it's just worked so well over the years. It's just worked really well.
Very good. Thank you.
Mm-hmm.
So at this point in time, you guys, did you want to open it up for questions and answers?
Yeah, because we want to limit this call tonight. Last time we were on this call, it was 4 hours. So that'll give them about an hour. We want to wrap it up around 9:30 or so.
Okay. So for those of you who have questions, press *2 and raise your hands, and you will be recognized. And it'll probably take a moment for the board to populate. So just press *2, and so that it'll raise your hand, and I will recognize you. And just as a sideline, when they talk in terms of credit cards and that sort of thing, this also applies to any kind of form of debt collection, including homeowners associations. So
correct.
Don't limit yourself by thinking only in terms of credit cards. There are other debt collection activities going on in addition to just credit cards.
Definitely. It could be medical bills, and personally, one of my favorite things to do is sue attorneys and the law firms that they represent.
Right. I don't see anybody with a *2 question.
You got to be kidding me.
Luz, you had a question?
Yeah. Hi, Jeff. It's Maritza. You might actually announce it *6 to be on to raise your hand to ask a question.
Oh, that's right. You never did do that.
Yeah.
Thank you so much.
Thank you. Luckily, I remember that from a previous call. So I hang on for a second. I need to get out of it. Sorry, I had to get out of earshot. So I am facing a judgment on a credit card that's fairly small. If it proceeds as a judgment, whatever your process is will be effective for that as well?
Absolutely. But why are you facing a judgment? Where are you at?
It's a credit card that I haven't been able to pay.
No, I understand that, but you said I'm facing a judgment. Have you been served on it? Have you been to court already on it?
I haven't been on court. Court case is coming up on Monday. And
okay, so you've been served. Have you answered it? Have you done anything?
I haven't done anything with it.
Okay, yeah, you need to answer.
When did they serve you?
In February. It's within.
Okay. Has it been more than 20 days?
Yeah.
Well, it doesn't matter, Larry. As long as you haven't had a default from the clerk, if you hurry up and you just file a simple motion for an extension of time.
I tried. I'm not. It's too late to do that. I tried to do that last week.
Not too late.
Did the clerk default you?
Yeah, it's too late. I even went to those self-help legal.
You can get it set aside. It's okay.
Yeah, absolutely. You need to file a motion to set aside the default judgment. What is the hearing on Monday that you're facing?
It's a motion where the attorney he's asking for a motion for judgment.
Is it a motion for summary judgment or default judgment?
Let me pull it up.
It sounds like small claims where they don't use the word summary.
Yeah.
They say motion for judgment. But we just did that for another client. We filed a request for leave to answer out of time. That's the language.
Correct.
Yeah, it's civil. It's not small claims.
All you do is say you have a meritorious defense, and then you ask. In your case, I don't know if I'd ask for more time. I might just go ahead and answer. It's a personal choice. I mean, Jesse might have his.
It's a notice of motion and judgment, memorandum of points and authorities, declaration, and. An affidavit
will overcome their statements. because they have no real affidavit, no competent fact witness?
Well, he also includes an agreement that I had signed last year.
Is your signature on it?
Yeah, a payment agreement that I ended up breaching on.
Is it dated? Is it dated?
Yeah.
Okay, and that's the original signature?
Yeah, I mean, it's a copy of the agreement, so.
But it's a copy or original?
It's a copy.
Well, then how do you know that represents the original?
Yeah.
Can you testify under penalty of perjury that that copy is an exact copy of the original document you have signed?
I
looked at it.
I'm not going to argue. I signed the documents.
Well, it's not a question of arguing. It's a question of making them prove their case, and I'm not trying to be antagonistic, but don't help them win their case, and that's true of any situation. But you still have plenty of recourse, and even if you get a judgment against you, which obviously everybody hopes you avoid, you still have recourse by suing the attorneys, by suing if there's a collection agency involved. They've almost certainly, I've never seen an instance where debt collectors have not violated the Fair Debt Collection Practices Act. I've never once seen it.
Yeah, the whole system is antagonistic. You always want to deny, make them prove their case. If they come with a copy of an agreement, say, that's not my signature. Make them prove it.
Or I can't identify that as a copy, exact copy of the original.
Right. You never give them the case. I mean, you could give them the case. I don't see what's the point then. Why do you even try? You can look at it that way. I like to look at it in terms of risk. What's at risk? Wage income and bank account cash, right?
Mm-hmm.
So then you just take the steps to protect that, and it doesn't matter. And don't even look at that particular account. I like to think that, imagine if you got sued for $1 million tomorrow, right? So just prepare for that. Then who cares about $400, right? And then like Larry said, go after them. Make them pay.
So what does your process entail?
Well, you set up the same type of debt that they're trying to create. Whether or not they get it's irrelevant. You put your debt in place, and then you put it in front of theirs, which is a procedure, filling out forms, and then that will block their ability to garnish wages. That's what they're wanting. And that's what they would go for. They would also want to go and take money out of your bank account.
Mm-hmm.
And so that takes about an hour to fix that. Mm. So that way you're not, it's not so much about the debt. It's about their ability to collect on it.
Mm-hmm.
So while they're not able to collect on it, you can collect against them.
Mm. And that's by setting up a debt against them for the same amount?
Yeah.
Well, not necessarily the same amount. It could be, if they violated the Fair Debt Collection Practices Act in any aspect in their collection of this alleged debt, then that's actual damages that you've gotten or that you've that they violated. In other words, you can claim that in either a counterclaim in the lawsuit that you're facing right now, or in a new lawsuit that you file, which you can do either in federal or state court.
Or both.
Yeah. Yeah, you can do both, actually. If depending on your state, you may have state statutes that are similar to the FDCPA, and we think probably all of them do. So in your situation, like John said, there's certain defensive things you can take, but at the same time, we strongly urge people to take offensive action.
Okay.
And, all of this is part of our system.
And so what kind of violations do you look for?
Well, there's a whole long list of them. I mean, if they've attempted to collect any amount different from the actual amount of the alleged debt, if they've tacked on interest or attorney's fees that were not in a contract, even assuming that you had a contract,
mm-hmm.
If they've, called you on your cell phone or home phone and either lied to you or tried to intimidate you or harassed you, those are violations. There's any number of things. If they've sent you, for instance, a collection letter and you've responded, and this is something we strongly encourage you to do, within 30 days, if you've sent them a dispute letter, then they're obligated to validate that debt before they proceed with any collection activity.
Okay.
So there's a whole long list of things under the Fair Debt Collection Practices Act. And like I said, I've never seen a situation where they have either clearly violated or at the very, very least you can make a plausible claim that they have violated the law.
Okay. And
if you don't mind me asking, this is Jess, how much is that judgment for, the amount?
Well, with the interest and the attorney fees tacked onto it, it's just under $4,000.
Oh, Lord. It's
I know.
so easy to get $4,000 worth of damages, yeah.
Yeah, it's not.
It's
a small one.
Yeah.
Probably easily got more than against them.
So,
yeah. As simple as that. It really is. It's so simple. If people only knew how simple it was, this country would just literally laugh its head off and go after all these sharks that are out there. Really. I mean, it's so simple.
So what is it? So if someone wanted to go through your process, it sounds like there's 3 different options here, with one with each of you guys?
No, we all work together. We've all come together to bring it all into one spot.
Okay. And so what?
Because that's what we're tired of. Everybody's out there. I get calls, emails. I get so many things. Hey, listen, they're selling my house tomorrow. They're doing this. They're doing that. They're doing the other. Why did you let it get here? Well, I paid so-and-so $5,000.
Mm-hmm.
I paid so-and-so $1,500. I paid so-and-so $3,000. Well, where's so-and-so? Well, I can't get him to call me back. He's disappeared. I'm like, you got to be kidding me. And this is like a constant thing out there. And I don't get it. I just don't understand it. Why anybody would have the desire to somebody who's already down, let's just hurt them some more. This doesn't make any sense at all.
So if somebody wanted to work with you guys, what is the process for that?
Well, you just go to the site and sign up. You're done. It's $99 to join and $49 a month. And if you don't make a few grand back in the first couple of months, it's on you. It's not on anybody else. Because everything's there. All the tools and resources are there for you to make easy money off these idiots. To stop your foreclosure, to stop these credit card judgments from getting to where you're at right now, to stop all these things dead in their tracks with simple questions. Once again, this is not science. Okay. If America only knew how easy it is, it'd literally blow your mind away.
What was the most recent one, Jess? Someone had faxed in a complaint and a cover letter, and they got an offer. It was like a $6,000 claim.
Yeah. One of the members in Georgia, sent in just an intent to sue letter. Said, here's what you violated. Here's the complaint. Here's the proof. And she's got $6,000 worth of violations just on her credit report alone. Yeah, they want to settle because what defenses do you have? Did you pull my credit? Yes. Did I give you permission? No. Did I apply for credit with you? No. What are you doing in my credit report?
Yeah, okay. Yeah, he's done that.
Does that make sense? I mean, you see what I mean, how simple this is today. I'll give you an example. One of my big cases, Larry and I were kind of laughing our heads off today. The attorney herself sends me a credit report as evidence. Well, guess what? Who gave you permissible purpose to look at that credit report? So now I'm suing her. So now I told her today in the email, I'm going to sue you, and it's going to separate you. Now there's a conflict of interest from your client. So I suggest your client hurry up and try to settle. That way I don't have to go there.
So
do you see how easy this is?
Yeah. So what's the website?
Marissa?
Yeah?
The email contained a link to take you there.
Oh.
Yeah, everybody's got an email. It's got a link that take you there. I don't want to, on the phone, go, everybody's got their link. Let's just leave it at that.
Okay.
So, I don't know who's listening and who's not. But
okay.
my whole point is that the attorney herself, trying to provide evidence that I've asked for, has literally shot herself in the foot. Now, she's liable for $1,000.
Yeah.
And she can't handle her client's case anymore if I want to push the issue. Because your client just violated, again, the Fair Credit Reporting Act. And you violate. Why did they give you my credit report when they haven't shown me that they even had the right to have my credit report? Not only once, but now they've given me the evidence. They've looked at it 4 different times. Up and beyond what my allegations are. So I gave her a choice. Literally today I gave her a choice. Tell your client to settle up. If not, I'm moving forward with litigation down in the state court. It's very simple. You've showed me, I only sued you because you called my cell phone twice. I asked you for all the phone records. I see you've called it 24 times. That's a minimum of a summary judgment of $12,000 right there. That's what I'm trying to say, guys. This is not hard. This is what we're trying to emphasize. But when you go into the court, and once again, I say this and I'll say this, I'm blue in the face, you have to use their own rules against them. If you come in there saying you didn't lend me money, the bank just did an exchange, you acquiesced to the RESPA, you acquiesced to TILA, you didn't show me the original note, you da-da-da-da-da-da, all this, you're going to talk yourself till you're blue in the face, and you're not going to get absolutely anywhere. And you might wind up in jail if you get an honorary judge. That's just the way it works. So we're as a group, I'm just as for the truth as anybody else, but I know what works. And what works is federal courts, because if you look at every single foreclosure case that comes out that has any decent ruling whatsoever is from the federal bankruptcy courts or from the federal courts, period. You never see monumentous rulings coming from these little kangaroo courts down below. It just doesn't happen. So when you start suing back and you start going through this, what I call the ballroom dance, okay, in the Fed court with the defendant that you're suing, who might be the guy who's trying to foreclose on you, who's the attorney who they hired to foreclose on you, who's the attorney, who's the trustee they've appointed on behalf of the, and you start sticking these people in federal court and you start asking them questions, they don't have a choice. They got to answer and they got to produce. And that's the beauty of the federal court. It's a lot easier. It's a lot more formal. There's no headaches. There's no aggravations. You're dealing with professional people. You're not dealing with a bunch of kangaroo judges. I don't know what else how else to put it. Can you, Larry? I mean, in the circuit courts, you just seem to get nothing done, no matter what.
Yeah, state courts certainly are very dicey. I mean, I've won cases as a defendant in state court, but I wouldn't recommend anybody to be in that position. It's always better to be on the offensive, and federal court usually is the most streamlined way of doing it. I mean, typically, you never even have to show your face in federal court other than, going by the clerk's office to drop off your pleadings.
Exactly. All right,
so even if you're afraid of being in court, that's just not going to happen usually in federal court.
Right. It's like I said, it's a simple process.
And there are questions here?
I'm sorry, Jeff?
That we need to move along on our questions?
Yeah.
Correct. That's what I said. Let's get on to the next one. God bless you. Have a great night, Maritza.
Thank you, Maritza. And we have an anonymous caller calling in, and I do not have a name for you. I just unmuted you, so you should have heard that.
That would be Delaware.
Hey, Phil, how are you? I know
Good,
that
gentlemen.
voice anywhere.
All right. Thank you very much for taking the call. Sorry that it was anonymous. That's unfortunately the way it came up. Had a foreclosure against me and my wife, and so what I understand from you professionals is that I am able then to go after the debt collector, which was the hired attorney, or their hired gun, as they'd call it.
Amen, brother.
So he can then be nailed for the $900,000+.
When did the judgment?
There's no judgment yet.
Okay.
They had I had a default judgment 2 Augusts back. I was out of country, and I'm still in my home.
But why are you in your home, Phil? Can I get a little credit here for helping you with?
Without question, I wouldn't be on this call if it wasn't for JT. If Jesse and his organization and his associates and also his friends in those other states that he talked about had never put me in contact with Jess, then I certainly wouldn't be on this call at this time or in my home. And this is my home, and I intend to keep it.
Amen,
but
brother.
I'm also willing to share the money that is returned back out of this process back to Jesse's organization or an organization that can assist other people as well. So from what I'm understanding, I'm able to keep my home, remain in my home, and be able then to go after the hired gun or the attorney or the debt collector, because that's what it tended to be, and go ahead and collect.
And the servicer also. Phil, never forget that the servicer or the alleged bank.
Yeah, the servicer. We'll go with you. Yes.
Yeah. Has no right to foreclose. And I found something today that I gave to Larry to read. I don't know if you read it, Larry, on TILA. Just a little quick, juicy little part of TILA. Obviously, the Helping Families Save Their Homes Act is one that's very juicy. But there's another little section of TILA there that a lot of people, I've never even seen an attorney discuss it. it was through my reading today that once again my diligence that I went through. But a servicer cannot foreclose. Okay, and this was April of 2010 Federal Reserve interim final rule under Reg Z.
Yeah, that's correct.
Okay, and it's regarding transfer notices, and at the end of the day, the notice must be given obviously within 30 days of the transfer of the new owner acquiring a loan. The acquisition date deemed to be the date that the acquisition is recognized in the new owner's books and records. And it goes on to discuss that basically a servicer has no beneficial interest in a loan. The servicer has no ownership interest in a loan, so a servicer cannot foreclose on that loan, period.
Well, you made another key point, and I read through it too, and I think there's some very interesting law here. But it states basically that the owner of the loan or the note or whatever has to notify you of its ownership.
Yes, that's right. Well, that's under the contract. That's under your, which I don't like to call a mortgage contract because it's not. The mortgage, it's under the mortgage, Section 20. It's under your note, and it's under, obviously, RESPA, and it's under TILA. So you've got them coming and going, Phil. It doesn't matter.
So it never places it under securities, though, right?
Yeah, and especially if it's securitized, then they have real issues because even the trust, for instance, the trustee is suing on behalf of the trust owners, correct? Well, under your pooling and servicing agreements, they have no knowledge of the underlying facts of anything. As a matter of fact, they're forbidden from knowing this information, who the owners are, what their interests are, et cetera, et cetera, et cetera. So they come into these courtrooms as, Bank of America or Deutsche Bank or any one of them as trustee for certificate number, whatever. Well, you can't do that. You can't do that. It's very simple, and you can kill them really, really quick, and you can hit them under the FDCPA immediately under the acts. You kill these people dead in their tracks. So for the simple fact.
So you're saying I'll be able to keep my home, go after the gunslinger, attorney, debt collector?
I can never guarantee anybody you can keep your home.
I understand
because,
that.
Like I said, rogue judges. You've been there,
Absolutely.
done that.
Yes.
Okay. You can. Nobody can look into the future, but I can sure tell you that you're going to come in and get them, and they're going to be really, really under a pickle when you start asking for documentation that they can't provide in that federal court, and they better provide it because the federal court ain't going to tolerate that nonsense.
Just the servicer also then can be tagged for the same amount?
Absolutely.
Okay, so
and the Supreme Court says now you can get actual monetary or not only the statutory damage but punitive damage too.
Right, and then the purchaser of that original mortgage, I believe they're somewhere in Japan right about now, so that would be all wet paperwork.
Yeah.
Yeah.
So there's a lot of issues there, Phil. Yeah, there's a lot of issues there. Right. You haven't tapped. Obviously, together we stopped your foreclosure for 2 years, but the reality is that you haven't tapped the suit going after these idiots.
Correct, absolutely, which I want to work with you guys. I definitely want to work with you guys on that, and I thank you very much for taking my call and assisting all the people that you gentlemen do.
Thanks. You.
So one more thing, and this is important for everybody to keep in mind, is the statute of limitations. For Fair Debt Collection Practices Act, it is 1 year. So any action that they've taken within the last year to attempt to collect an alleged debt would be covered, but nothing beyond that. Now, you may have state laws. For instance, in Florida, you've got something similar to FDCPA, which goes back 2 years. But even if it's something old, and this is something that we're working on right now, is a process for vacating void judgments. And that's a lot trickier. And again, as Jesse said, there's never any guarantees, but this is something that we're really focused hard on, and we want to provide the best information we can about that process to our members.
I appreciate it. Absolutely. I think I'm watching that monthly chopping block at the sheriff's sale, so I'm constantly looking to see. I'm off for another month. I'm not on it, so if so, I'll have to take it from there. But again, I appreciate all the efforts of your organization and all you gentlemen out there and the ladies that are pushing hard for this. Thanks again for your intel, guys.
Yeah, man. We just got to help people quit losing their homes. And
we also, as a consumer, need to be a little more astute on what it is we're doing ourselves.
Well, if I tell you of all things today, guys, and I don't know, once again, how many people are on this call, and I don't want to bore anybody to death, but I'll tell you something that's very interesting. Today in my office, and John was there early because he had to leave today. He had some electrician or something come to his house. I had a gentleman from Taiwan who came here as an exchange student. He's a law student. Okay, he sat with me. He's actually one of my clients' brother. She's a doctor. He's an attorney. He's going for his bar license over in New York here soon. And I asked him a simple question. I says, throughout your studies, how many times did they reference you back to Black's Law Dictionary? Simple question. That was my first question. And he looked at me and said, what is Black's Law Dictionary? Okay, here's the University of Florida law student, 7 years. And I told it's $1,060 per credit hour. And he had no idea of what Black's Law Dictionary was.
Especially Volume 6.
Okay? So, once again, if you just understand that you can outwit these guys in 5 minutes, literally. He told me after 1 hour with me, he said, Jesse, I've learned more literally in an hour than I have in the last 3 years at law school. And it's not no exaggeration. He said, I can't believe it. It's ridiculous what they don't show us. And he says in Taiwan, it's the opposite. In Taiwan, there's very few lawyers, and they promote the people to educate themselves on the law. It's publicly promoted. When you go to court, they don't want you to bring an attorney. They want you to go represent yourself. They want you to be up on and savvy on the law. And it's publicly promoted. He says, attorneys make no money in my country. That's why I'm here. Because here, Americans they don't want to take the responsibility. They just pass it on to somebody else. Let them do it. And that's the way it works. He's no dummy. But I couldn't believe what he had told me today. It blew me away what he had told me today in our conversation, which is a little over an hour. So, but anyway, go ahead. Next question. We got to get rolling.
Hello?
Okay. I'm going to take a chance. It's identified as Karen out of Georgia, I believe it is. Of course, it could be.
Hey, guys. How you doing?
How you doing, Karen?
Speakerphone, Karen.
Yeah, I'm good. You guys okay tonight?
Yes, ma'am. No complaints.
I just wanted to run through my scenario again. I started receiving default letters from Chase last year, August, in reference to the mortgage that was being paid not being applied to the account. Now, the backstory or sidebar to this is that I'm disabled, and my mother, she's been helping me for the last 7 or 8 years with this mortgage, and she pays it faithfully on the 1st or the 15th every month. And so I knew the payments had been made. When I got this situation came to my attention, what I did, I went down to the bank, and first let me stop here and say that those people at the bank, they are just people sitting there working. They have no idea about your mortgage or what's going on, and the only thing that they can do is make a 1-800 customer service phone call like what you can do, except for give their ID number. I asked them what the story was. Every time we call customer service, we got 6 different scenarios. But the bottom line of what they did was they projected my escrow account. I'm disabled, as I stated. My escrow, my property taxes have not changed in the last 5 years. And so instead of taking one property tax payment, they paid one and projected the other, which put my escrow account into the negative. Then from that point on, all the payments that she made were going into suspension because they never applied them to the mortgage payment. So everything was always behind. So now what they have is they started harassment by sending me the letters of default, and every other day or so I get a UPS truck or a FedEx truck. The last one I got said to me, this is the final notice for a modification package. They are harassing me into modifying the loan. When I filled out a modification package in September, and they denied it out and outright. They didn't put me through a trial period or anything. They just denied it. So now I've got 4 or 5 or 6 envelopes with modification package in there for me to sign and send back because they want me to recontract, and I'm not going to do that. I've sent out qualified written requests to every address that was harassing me, and I wanted to know, as a preemptive strike, what is the next thing that I need to gear down to be able to do preparing for.
Okay, Karen, I'm just going to jump in real quick, and Larry, you can take over from there. But did you guys read, or are you an actual member?
I am a member.
Okay,
this is the best thing I've ever done.
The gentleman that sent out the qualified written request, they failed to answer. He sued him, and he foreclosed on their local Wells Fargo branch, all for $1,200.
I didn't see that.
Did you read that article?
I didn't see that article.
You guys check the news daily, yeah. So depending on how they answered, remember, when they dig into your money, because that escrow account, they're being the fiduciaries of your money. It's not their money, It's your money.
Right.
There's a big responsibility that goes with that. So if you ask for an accounting specific to that account and say, listen, I need an accounting of this escrow. I believe that you're wrong by double charging or projecting my taxes without any reason. Did the county, call you or say, hey, we're going to raise taxes next year?
They can't because of my disability. My disability.
Okay. No. I'm asking you. In the letter, you would ask Chase this. I'm not asking you.
Okay.
I'm telling you.
Okay.
You would ask them for verification, validation of the escrow amounts. Okay. If they don't come back with some legitimate answer, and you tell them, listen, I'm disabled. My taxes are never going to change. If anything, they'll go down, okay? Why did you project this tax and take this money and mess up my entire accounting? Now you're refusing to take payments. So what happens is once you do that and they don't respond, and I don't know if they've responded to your existing ones that you said you've sent out.
No, they haven't yet.
How long has it been?
It's not within the 20 days. I sent the first. I sent them all about a week ago.
Oh, okay. Well, just wait. Just be patient. But, I think I discussed this before on one of our weekly webinars that we need to stay diligent on top of this because if they do not and they fail to answer, number one, obviously FDCPA, but you got TILA arrest, but you got all kinds of damages that go there. And now on top of that, you're going to have punitive damages. Because you're handicapped, this is stressing you and your mother out. You don't need this kind of stuff.
I'm totally stressed out, yes.
Exactly. So you don't need this kind of stuff, and if you do it right, and they're without fail going to screw up. Do you not agree, Larry?
I agree.
So if you do it the right way, you're going to put them in a corner.
Okay, so right now, just wait for them not to reply. Is that what
I mean that you wait for them to reply or not reply, whatever it may be, but you should assume they are not going to provide you with the right answers and the right resolution of this issue. And you should be, hopefully, ready to sue them or at the very least threaten to sue them. And it could be for violations of RESPA, the Real Estate Settlement Practices Act. It could be for TILA, which Jesse was talking about before. It could be FDCPA. It could be Fair Credit Reporting Act.
It could be all of them.
All of it, yeah.
Absolutely.
Okay, so right now what I'm doing is just being prepared to take them to court, and that is federal court, right?
Yeah, because everything that we just talked about, the 4 laws that I told you are all federal laws. Now, in theory, you could sue in state court for this stuff, but I guarantee they're going to remove it to federal court, so you might as well just start there. That's where you're going to end up.
And I don't have to wait for any of this. I can just wait for my time factor to go through, which is the 20 days for them to respond and the 60 days for them to actually answer those requests. And once they have not done that, then I can go and strike first.
Yeah, you can absolutely strike first, and keep in mind it's a very easy process to amend a complaint, especially in federal court.
Okay.
So even if they violate during the course of the lawsuit up until a certain time, which could be several months down the line, you can amend your complaint to add in those additional counts.
Okay. Well, I'll do that. Well, I'll be on the webinar with the lawsuit filing because that's what's coming up tomorrow, I think.
Right. I'll be doing a webinar on filing of a lawsuit.
Yeah, to understand that process better, because in the other subsection, with taking their money on the creditors and everything. I've been working with that as well. I did send out an intent to sue letter, and I honestly lost my nerve when it came to, I had to get down there right away because it was one that I found where the statute for Fair Debt Credit Practicing Act was running out. But I did hear back from one of the ladies at the collection agency. I don't feel I'm up to par yet or as experienced enough to speak with them, so I did give her my email address for us to correspond that way. She did write me back and say that she was going to investigate the matter to look, so I anticipate hearing something from her tomorrow, and if not, I will respond to her in kind and tell her that I am going to file suit, or just go down there and file it.
Yeah,
because
tell her.
exactly.
Just make it clear, Karen, right? Statute of limitations running out. I'm going to have to file the suit, and it's just, you're going to incur more charges, but I have to do it because if not, I'm going to lose my remedy, and you can't do that. So no matter what, you got to make sure you stay diligent. That's all.
And when you
Karen, did you see that I responded to? Hold on a second. Did you see that I responded to your forum question today about that very issue?
I did. A few minutes ago.
Okay.
A few minutes ago. Yes.
Oh, okay, good.
That's what I'm going to do.
You're just about to file. You haven't exceeded the statute of limitations. Is that correct?
For the FDCPA, I did, but the FCRA, I have not. And so, okay,
well, you should be fine on FCRA because that goes back at least 2 years, if not 5 years.
I'm fine on that. So, but what I wanted to say was that, one of the things that I found the helpful for the things that you tell us all is to personalize these letters according to our own situation. I picked one of the intent to sue letter templates that you had out there, and I did just that. I personalized it. And at the bottom of it, I did make aware of the fact that I was disabled. And there was a human interest story article printed about me in the state of New Jersey. And I copied that and put it in there just to tell them that I just want to let you know who's showing up to court. I am a lady who has had brain surgery in the month of March. I had both my legs amputated below the knee in the month of June. I had my right hand amputated in the month of July, and 4 fingers, 2 fully and 2 partly, amputated on my left hand in the month of August. This all happened in 1992. I had a very rare vascular illness that people say if you live, you only live 1 to 5 years after that, and this was 20 years ago. So I just wanted to let them know who would be showing up to court. I drive, I type, I do all those things, run a house, take care of my son. He's grown, but he's still back home. I run a household, chief cook and bottle washer. But my intent is when I go into court, I will not have my legs on. I will be going just as I am.
There you go.
Well, good for you, Karen. And I hope you live another 50 years and make these people's lives miserable like they've tried to make your life miserable and a whole bunch of other people.
I am. I'm going to start getting my documentation ready for when I don't hear from them. And I'll be on the webinar tomorrow to listen about the lawsuit process, actually, so that I'll know what to do. Some of the things I already listened to. And I just want to, and I thank you for answering my question, but I also wanted to tell you guys, for anybody that's listening that's not a member, for me, everything I do, I have to calculate because I live off of Social Security disability. But that $99 and the $49 payment that's coming up is some of the best money that I have ever spent. It's just like that young Japanese man said, that we rely on other people. We don't dig into information for ourselves. And what the government, I think, and these agencies and these loan people and banks bank on, the reason why they are so successful in doing the things that they do is because we are not going to investigate it ourselves. We're not going to find out that there are penalties written in TILA and RESPA and the Fair Debt Credit Practicing Act. We don't know anything about it. And I have been telling everyone I can possibly tell about what you all are doing, and I just want to say a resounding thank you.
Well, thank you so much, Karen. We appreciate that. And that's the whole intent, is to empower people to get out there with real information, real results, that everybody can afford. And I encouraged everybody last week on our webinar, listen, if you know somebody else and you're a member, grab that person and help them out. Do not let them go homeless. Remember, they got kids, they got family. Do not let that happen. So we encourage that too.
And as we grow, I'd like to ask for like some of the more experienced people in the same towns and the same states, like if we could get together and help each other out that way. If there's somebody that's been in it, you know, longer than I have, which is a hot minute, and, you know, in Georgia, that, you know, we could all some kind of way get each other's numbers and you know, just bounce things off.
Well, that's your forum. Your forum is your vehicle. We have an open forum. Everybody can connect there. They can do whatever they want to do. It's there for everybody to connect. So, all right, Karen, we're going to move on to the next question.
Thank you so much. Okay, good night.
Have a great night.
Okay, you too. Good night.
We'll talk to you tomorrow. Okay, sweetie.
Okay, honey. All right, bye-bye.
Jeff, next question.
A number of people have fallen off the board, so it's press star 2 to raise your hand so that you can ask your questions.
Well, if we're out of questions, I'm more than happy to cut it short. Obviously, it's almost the top of the hour, so it's not going to hurt my feelings any.
Okay. If that's what you wish to do.
Well, I don't see any more. Do you see any more? You actually have the board. I do not.
I have the board. Wait a minute. We got Bob. Bob has a question.
Hey, guys. How you doing?
Good, Bob. How are you, sir?
All right. Hey, my question is this. I've been working with Jeff for a while, and he's steered us to you guys, and I've been trying to do some homework and so forth. My question basically is, we have a construction loan that we never got finalized. It was supposed to go into an end loan, and it just didn't happen. Since then, they've started a default complaint against us and got that in New Jersey courts, the local superior court. But at the same time, the bank wound up being bought out by another bank. Now, since then, the new bank has started, went on basically onto, it's my wife's credits. They went on her credit and have been reporting ever since that, you know, we're late and so forth. Before that, there was no recordation of that from the previous bank. So I don't know if I can try to go after them anyway with your program or not.
Absolutely. Listen, Bob, and I'm going to let Larry answer that question for you, but they're already in violation of several things. But listen, our program, there's nothing that you can't go after these people for. So never doubt that there's resolution with the program. Never doubt that at all. Okay. No matter what the situation is, you always have a remedy.
Gotcha.
That's all I'm going to say about that. So people have to understand that using their own rules against them is enough. You don't need to come up with all these crazy things. They screw up on their own.
So I guess I would use the collecting terms, or how would you fashion that?
You got CRA, you got RESPA in there, you got Reg Z. You've got several violations already in there.
Gotcha.
Real quick, Bob, so this was a personal loan for your house, is that correct?
It was a construction loan, which we built a house.
It's Dr. LeConte, yeah. It's the same thing as Dr. LeConte. Chase Bank gave him a construction loan. They were supposed to turn it to a perm loan from $2 million. The house depreciated to $1 million. He was paying $18,000 a month mortgage. He was down to 10, and the thing just dumped. They never did follow through with the loan. They couldn't do anything because the house lost all its value, et cetera, et cetera. And I've had him out of foreclosure since August of 2008, I believe it is. They haven't been able to do anything. As a matter of fact, they haven't even heard the motion yet. So, you know.
Interesting.
Bob, did you say the loan did go through completely or did not?
No, what happened was we finished the house. We were looking to go to the end loan in New Jersey. You have to have an end loan before you can get a construction loan, and they didn't guarantee us that, but that's what they were supposed to do, or they were not allowed by New Jersey state banking law to give out a construction loan. We got to the end of the loan. We wanted to go ahead and get a permanent loan, and they said our house was underwater, and that's the reason why they wouldn't do it. And at the same time, they were being bought out by another bank because they had a large cachet of loans that were not working. I think they were going to go under. So this other thrift bank in New Jersey bought them out. And now that thrift bank is reporting on us, which the other bank couldn't do before because it was a construction loan. It wasn't actually a physical completed property that would be recognized through the town or through the state, I believe.
Okay. Well, two easy things that you can do right now is to send a debt validation letter to whoever's trying to collect, and it's better if you can do that within 30 days of their first contact, but better late than never. And the other thing is,
here's the thing with that. I'm sorry to interrupt. We did send a QWR out to the original bank last summer in August, and they tried to tell us they weren't part of RESPA and part of TILA because it was a construction loan, and that's all hooey because we found out that they are part of RESPA. And I guess, are you saying should we send it out to the new bank now also, or?
Well, I would send, we're talking about two different things, but I would do both. Send a debt validation letter under the Fair Debt Collection Practices Act, but send a qualified written request letter, which is what you've already done, and you may just want to send exactly the same letter to this new company.
Right.
And also what you want to do is get all three of your, or maybe your wife's credit reports and dispute the item. And that way you're setting up for violations of Fair Credit Reporting Act, too.
Gotcha, Larry. Okay.
Yeah.
And
plus, the other thing is, you say a new bank. Is it a new bank or is it a new servicer?
Well, I believe they bought out the previous bank of what the letter they sent out, that it was Sterling Bank was bought out by Roma Bank, and they've become the new owner of the mortgage and note. Who knows about that, because it might have been traded a few million times.
Well, exactly. Who knows? Make them prove it.
Records. I tell everybody, go look in public records, because when you said, how long ago was this?
When the bank was sold?
Yeah, when they transferred your loan, allegedly.
They did it in July of this last year.
2010. Well, great.
Yes, sir.
Anything after May 11, 2009, they had 30 days, or as soon as possible, to let you know that this was done. It has to be publicly recorded, and they got to tell you where it's publicly recorded, et cetera, et cetera, et cetera. So,
is that a federal statute or state statute?
Yes, that's federal. That's TILA. It was the amended TILA that was buried in the Helping Your Family Save Your Homes Act of 2009.
Jesse, do you know what the citation is for that? What the statute?
It's public law. If I'm not mistaken, it was public law 111. And it's a tricky citation. It is buried. When I say buried, it's buried. So it's a very little tricky citation. I don't want to give you one, but it is public law. Just look, put in this search term in Google, buried in the Helping Your Families Save Their Home Act. That's it. Put that whole long search criteria in Google, and it'll come up.
Okay, because it's funny, they did not. The only thing they
private remedy of up to $4,000 there, by the way.
Oh, that's
private
nice.
right of action.
Because there was no assignment whatsoever, none. I looked in the public records. I was never.
You don't
sent.
Want to let them know that. You don't want.
No,
to let
I'm not going to say a word. They'll read it in court papers. Yeah.
Yeah, exactly. You sue them under TILA, RESPA, FDCPA, FCRA. You challenge all that with the credit reporting agencies first for your wife. Like I say, go join our site, dude. I mean, it's $150 to get in there. You're done. You got it all right there at your fingertips.
Where do I? How can I pay that? And I send it to you now.
Yeah, I don't. Just get on right there. Go to the link Jeff sent you. I don't like to discuss the website name on the phone, so
okay, not a problem.
Go. It's right there on your links.
Okay. Now that's awesome. I'll definitely do that.
I'm telling you, it's all at your fingertips. All that information's right there. And there's probably, I would say, as a matter of fact, we've made the corporate decision to slow down our webinars because we're doing 3 a week. It's overwhelming people. It's too much information. So there's such a backlog of webinars. We keep tabs on where people go, and people are listening to the webinars 3 and 4 times after we give the webinar because it's just too much. They can't get it. It's just too much information. So we've decided to slow it down, do maybe this call every Tuesday night, which is an open call for members, non-members, et cetera, and then do maybe 1 webinar a week. John will do one this week. Larry will do one next week. I'll do one the following, just to help people catch up. And then do this open call on Tuesday nights and along with the forum because it's just too much. Even as Karen said, it's just like it's a lot of information.
Yeah, it is. No doubt. I've been on a couple, or been on a couple before, I think, or at least one that was full time. It's just
it is only our second time that we've done a call, and we've had to do it because everybody's asking and begging for it.
Right.
So and of course, tell everybody in the world. Every Tuesday we'll send out an email, or Monday, hey guys, remember to call, and then eventually, you'll get your 1,000 people on the call, and that's it. We can help as many people as we can, but if everybody shuts up about it, nobody's going to hear anything. We need to help each other get out there and stop this nonsense.
I agree, and I appreciate you guys' help on it, too.
Yeah, man.
Thanks, guys.
Next question, Jeff. God bless you guys.
That was it on the questions.
Okay. Well, I guess that's a wrap. Everybody's got their links that they however you got to this call. Is you know where to go if you want to join, if you want to go check it out. There's a bunch of free information there, some free webinars, free downloads. There's more free information. Just on our one free webinar, Larry teaches you how to make a few grand. John and myself put in together with one of the downloads that's free that'll stop any and all foreclosures in this country coast to coast, non-judicial, judicial, credit card issues. We've got stuff. You just download it for free. It's there to at least to get you rolling and get you started if you don't have the money, so you don't get run over or you don't get in a position of not being able to answer or make a move on these guys when you get served. So if anything, worst case scenario, go to the site, put in your email address and your name, and you get access to all this other stuff that's there, free of charge. At least it'll help you cover your bases. So I'll leave it at that unless you guys have anything else to say.
Jesse's underselling this. You guys got to get that get the free procedures. It'll blow you away. It's really good.
Well, yeah. I don't want to brag. I mean, literally, it'll stop foreclosure coast to coast.
Yeah, it will.
Well, we're giving away for free people charging $5,000 for it, and that's a fact.
Exactly.
That's a fact.
Thank you. Thank you, David.
I appreciate everybody on the call. Yep.
All right, guys. Have a great night. We'll see you next Tuesday.
Okie dokie.
Thanks, everybody.